The Nigerian Senate has resolved to appeal the recent judgment by a federal high court sitting in Umuahia, nullifying the provisions of Section 84, subsection 12 of the newly amended Electoral Act 2022 passed by the National Assembly. The resolution followed a motion titled Urgent Need to Appeal Judgment of the Federal High Court Umuahia on suit number FHC/UM/CS/26/2022 on Section 84, subsection 12 of the Electoral Act 2022. The motion was sponsored by Senator George Sekibo, Rivers East, and co-sponsored by 77 other lawmakers. Presenting the motion, Senator Sekibo said, letting the court judgment go without consent will become precedent, urging the National Assembly to appeal the judgment in a suit marked FHC/MU/SC/26/2022 to set aside the judgment.
The Senate believes that the Senate of the Federal Republic of Nigeria should show concern on the judgment, especially when she was not given opportunity to represent herself in a matter such as this that emanates from her legitimate functions. The Senate finally believes further that letting the judgment to go without concern will become a precedent on which any person could go to the court and obtain judgment to ridicule the good intentions of the National Assembly as an institution. The Senate accordingly resolved to 1. Follow the appropriate channel and appeal the judgment in suit marked FAC/UM/CS/26/2022 for the court to set aside the judgment, as the judgment was reached without due consideration of the constitutional interpretation in Section 318 of the 1999 Constitution as amended.
Contributing to the debate, Senator Sabi Abdullahi, in support of the motion, urged his colleagues to consider the motion as submitted.
Of course, in seconding this, Mr. President, distinguished colleagues, let me add that the content of the motion is straightforward, is clear enough, and the resolution sought is also clear enough. And therefore, on the basis of this, Mr. President, distinguished colleagues, I want to urge that without much ado, I invite and request humbly that my colleagues do consider this motion as submitted, and to say that we ask that the question be put for us to consider the prayers.
Justice Evelyn Anyadike, in a judgment, held that the section of the Act was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever, and ought to be struck down, as it cannot stand when it is in violation of the clear provisions of the Constitution. Consequently, the court ordered the Attorney General of the Federation to forthwith delete the said subsection 12 of Section 84 from the body of the Electoral Act.